The United States' unclear crypto policies have led businesses like Ripple to explore investing outside the nation. Brad Garlinghouse has claimed the Ripple CEO advised the U.S. to follow the U.K. and Singapore. How do you think this will affect the cryptocurrency and the U.S. economy? We will answer these questions in today's video based on a prior court order. Defense attorney and former federal prosecutor James K. Filan anticipates the release of the controversial Hyman speech materials on June 6. Bill Hyman, a former director of the SEC's corporate finance section, made statements in 2018 suggesting that ETH, was not a security, and these statements are the subject of the Hyman paper. The records include internal SEC debate and discussion over the speech in question. Filan, who has been keeping a close eye on the SEC's UV's Ripple case for the last 2 years, updated his followers on May 17 about the possibility of unsealing the papers. In accordance with the court's order on September 12, 2022, the parties have 21 days to submit publicly available redacted copies of the summary judgment papers in accordance with the sealing judgment papers From the date of the judgment yesterday until June 6 is 21 days. However, if the SEC files an appeal or if a settlement is reached, the stated schedule may be altered, according to some observers. Jeremy Hogan, partner at Hogan and another attorney watching the case, said the SEC has about 10 days to submit an appeal to this particular judgment. Some members of the XRP community, like Ashley Prosperone, think that the possibility of unsealing the papers might encourage both parties to negotiate a settlement, as they each could be sitting on material that they don't want the other to have access to. Ripple CEO Brad Garlinghouse said on Twitter on May 16 that the company is eager for the unredacted Hyman emails to be publicly available soon. Ripple Labs has had access to the records for some time, but it still considers this part of the case to be crucial in refuting the SEC's claims that XRP is a security. Towards the end of December, the SEC filed a request to seal the records from public view, citing no relevance to the result of the case and the SEC's purpose outweighing the public's right to see the documents as reasons for doing so. The request was formally refused on May 16, giving Ripple Labs a victory this week. Europe has been a significant beneficiary of the SEC's crypto business misunderstanding. According to Ripple CEO Brad Garlinghouse, crypto enterprises must invest abroad due to misunderstanding. Garlinghouse, whose business purchased Swiss crypto startup Medico on May 17, told CNBC that the SEC's crackdown would restrict his company's contacts with U.S. corporations and residents. Unfortunately, the SEC crackdown has encouraged companies like Ripple to invest more abroad. For the same reason, 95% of our consumers are non-U.S., Garlinghouse remarked. The CEO called Ripple's purchase of Swiss firm Medico a perfect fit in terms of clients and location. Medico, bought for $250 million, is anticipated to provide Ripple access to its A-list customers, including BNP Paribas, Citi, and Société Générale, as well as boost its international reach. When questioned about the ideal crypto regulatory structure post-OFF's collapse, Garlinghouse advised that U.S. authorities look to the UK, UAE, and Singapore, who have stated how they would handle digital assets. Garlinghouse said clarity allows entrepreneurs and investors to engage constructively with regulators. Internal SEC communications suggest Ripple's XSP coin may not be a security. These communications suggest that XRP may not meet the Howey test, a condition for investment contracts. John Deaton, a legal pundit, discovered these communications in Ripple's opposition and reply papers footnotes. Ripple's legal team's inattention to these communications' consequences perplexed Deaton. Exhibit 220 emails suggest that XRP may not pass the Howey test. Deaton acknowledges that the email's importance was first overlooked because to their placement inside a phrase addressing independent market players' SEC analysis that XRP was not a security. Ripple, the payment company, and the SEC may be negotiating a settlement amid the legal battle. Ripple asked a 1-week extension to file public, redacted versions of its cross motions for summary judgment and supporting exhibits, including the Hinman documents. These SEC papers highlight former SEC Director William Hinman's 2018 statement declaring Bitcoin, Bethesda, and Ethereum, ETH not securities. Attorney and excerpt supporter John Deaton expects the SEC will continue the lawsuit when the Hinman docs are unsealed. He believes that Ripple would have settled before receiving these materials. Deaton believes SEC Chair Gary Gensler, who opposes the crypto business, will see the case through, saying, Judge Annalisa Torres denied the SEC's attempt to seal the disputed Hyman papers, allowing Ripple to postpone their release until June 13. According to a court order, the documents, which include former SEC Division Director William Hyman's 2018 summit speech declaring Ethereum, ETH, and Bitcoin, BCE not securities, were expected to be released on June 6. The court order on September 9, 2022 specified that both parties had precisely 21 days following the sealing judgment to produce public redacted summary judgment materials. Since the judge ruled on May 16, defense counsel James Key. Filan anticipated these discoveries on June 6. On May 19, Filan tweeted that Ripple and the securities regulator requested a one-week extension until June 13, 2020, to file public redacted versions of cross motions for summary judgments and accompanying exhibits, which includes the Hinman materials. As he later confirmed, the judge approved this request, which the parties filed in light of the voluminous nature of the materials and redactions. As was the case with the previous expert testimony motions, called Dobert motions, which were significantly less voluminous, the letter states. According to pro-Ripple lawyer John Deaton, the Hyman email release will include Brett Redfern, SEC Director of the Division of Trading and Markets, who told Hymans that this speech is going to lead to more market confusion, as Deaton told Fox Business journalist Elir Terret on May 21. Ripple's chief legal officer, Stuart Alderoty, previously cited a U.S. Supreme Court opinion that legal teams and courts should adapt factors from old cases to fit the evolving legal landscape, suggesting that the Howey test should be interpreted within the common law framework. Last week, he cited a 1976 Supreme Court ruling in which the SEC ruled that art lithographs offered for investment were not securities if the vendor had no post-sale contractual commitments to the buyer. Reasonable grounds to conclude that excerpt does not satisfy all elements of the Howey analysis and is therefore not a security for purposes of the federal securities laws, the email states. The SEC's case against Ripple hinges on XRP and other cryptocurrencies meeting the Howey test definition of securities. Thus, any SEC official or internal document stating that XRP is not a security might be fatal to its argument. Deaton added that the SEC's representative may have been quoting another XRP study. Pro-crypto lawyer Bill Morgan believed in SEC attorney sent the message. Morgan added, most likely in SEC attorney, given how many were involved and commented on Hyman's speech expressing his personal opinion. Many expect the SEC to disclose Hyman emails to clarify these suspicions. Ripple has made many platform growth-focused announcements in the previous week. Ripple acquired Medico for $250 million. Focus on growth opportunities outside the U.S. was the company's CEO Brad Garlinghouse's explanation for the acquisition. The crypto payment business said its C+C platform works with the XRP ledger and token,